With all this wiener stuff going on, there's actually something that's occurring that directly affects your life and your health and your welfare and that of your family. In the circuit court today in Atlanta, Georgia, the 11th Circuit, the government appealed the district court case out of Florida, the case involving 26 states, among others, insisting that the government had the power to compel you as an individual to enter into private contracts to purchase whatever the government demands that you purchase. In that courtroom today, your liberties were on the table, with a government headed by Barack Obama arguing, in essence, that the court should abandon the Constitution and individual liberty, that the court should abandon our time-tested capitalist system, and with one law and in one decision, forever change the face of this nation. I don't know how many other hosts are focused on this, but I am focused on this like a laser. Because unlike the other hosts, I'm involved in this litigation, as well as others, and as well as other cases involving the EPA and immigration. But this case is a seminal case. This case will decide what kind of nation we are, or what kind of nation we will become. A massive piece of legislation passed in the middle of the night against the will of the people, with all kinds of tyrannical administrative activities involved in it. And the issue is whether these courts are going to show fidelity to the Constitution or not. This isn't even a close case. It's not even a close case. And it appears, we have to be careful about oral arguments and reactions of judges, but it does appear that at least two of the judges of the three-judge panel on the 11th Circuit understood what was going on. I turned to a quick analysis by Ilya Shapiro at the Cato Institute, and he writes that the most important appeal of the Obamacare constitutional saga, today was the best day yet for individual freedom. The government's lawyer, Neil Katyal, spent most of the hearing on the ropes, with the judicial panel extremely cautious not to extend federal power beyond its present outer limits of regulating economic activity that has a substantial aggregate effect on interstate commerce. That's the usual test. As the lawyer representing 26 states against the federal government said, the whole reason we do this is to protect liberty. With those words, former Solicitor General Paul Clement reached the essence of the Obamacare lawsuits. This is a big deal, not because we're dealing with a huge reorganization of the healthcare industry, but because our most fundamental first principle is at stake. We limit government power so people can live their lives the way they want. This legal process is not an academic exercise to map the precise contours of the Commerce Clause or Necessary and Proper Clause, or even to vindicate our commitment to federalism or judicial review. All of these are worthy endeavors, are just means to achieve the goal of maximizing human freedom and flourishing. That is the very reason the government exists in the first place. And the 11th Circuit judges saw that. Countless times, Judge Dubina and Marcus demanded that the government articulate constitutional limiting principles to the power it asserted. And countless times they pointed out that never in history has Congress tried to compel people to engage in commerce as a means of regulating commerce. Even Judge Hull, the liberal, reputed to be the most liberal member of the panel, conducted a withering cross-examination to establish that the individual mandate didn't help that many people get affordable care, that the majority of the people currently without coverage would be exempt from the requirement. In other words, she's trying to save the law and parse out the individual mandate. Well, this audience is a smart audience. This audience cares about liberty and private property rights and the Constitution, because we talk about it all the time. And before I had a national audience, the extent, the depth, the breadth of these discussions were limited. Important, but limited. And so I jump in again today to explain this in more detail. Because I promise you, this is more important than the fact that another picture's out of Wiener's Wiener, and this time without cover. This affects your life. This affects this society. Now, in this brief we filed at Landmark Legal Foundation, and you can go to landmarklegal.org and get a copy of the brief, all of our briefs in this case and also other cases related to Obamacare, as well as a recent filing a week ago against cap-and-trade regulations. We're the lead amicus brief in that case. Feel free to read them. But this case, as we wrote to this court, this case is about, now tell me if this doesn't sound similar to the analysis of what the judges were asking. And by the way, we were asked by the states to get involved in this litigation. This case is about individual liberty, we wrote, state sovereignty and federalism. Indeed, whether there remain any limits on the power and reach of the federal government is the fundamental question before this court. The government's defense of the individual mandate, if accepted, requires the court to disregard more than 220 years of Commerce Clause application and Supreme Court precedent, fundamentally misapply the necessary proper clause, and disregard the Constitution's requirements for the laying and collection of taxes. The heavy-handed demands of temporary politicians who seek to change fundamentally and permanently the relationship between the citizen and government in a manner that no past Congress or executive have undertaken and which the Constitution clearly does not allow must not be given this court's imprimatur. The district court correctly rejected the individual mandate, and its penalty provision is unconstitutional. Landmark Legal Foundation urges this court to uphold the district court's position. The Commerce Clause is written in uncomplicated, plain English. Article 1, Section 8 says this, quote, "The Congress shall have power to regulate commerce with foreign nations and among the several states and with the Indian tribes," unquote. Now, Congress can tax interstate commerce. It can regulate interstate commerce. It can even prohibit certain types of interstate commerce. There is nothing in the history of this nation, let alone the history of the Constitution and the Commerce Clause, however, permitting the federal government to compel an individual to enter into a legally binding private contract against the individual's will and interests simply because the individual is living and breathing. Such a radical departure from precedent, law, and logic has never been contemplated, let alone imposed upon the American people. This is crucial, ladies and gentlemen. This is crucial. We have a president and his lawyers in court who are rejecting our Constitution, who are rejecting individual rights and liberty, who are rejecting your right to make a decision or not to enter into a private contract. If this is not totalitarianism, I don't know what is. The federal government's flagship case, stick with me on this, because I think it's going to be very interesting to many of you. And we've talked about this case before, and I've written about it many times. Wickard versus Filburn, 1942, Supreme Court. The government first waved this case around, but we boxed them in. We say this in no way supports Obamacare's individual mandate. In fact, it underscores its unconstitutionality. In that case, the government did not mandate a farmer to grow wheat. It sought to regulate the wheat the farmer, by his own free will, chose to grow. Herein lies the obstacle the government cannot overcome. Under the federal government's logic, justifying a congressional power to compel private individuals to initiate private economic activity, what would stop the government from compelling a farmer to grow wheat or to grow corn or to raise livestock or to undertake some other activity he has no intention of pursuing? In fact, what would stop the federal government from compelling any private individual to participate in agricultural activities or any other private activities? And once unleashed, what are the limits to this new unconstitutional grant of power? See, when you write these briefs, my view was, put it to the government court. Put it to the government. Make them define the limits of this power, because they can't. You know why? There are none. Continuing with our brief, Landmark Legal Foundation. Can the federal government compel an individual to purchase certain fruits and vegetables that are said to be healthy in order to limit the federal treasury's exposure to health care-related costs? We raised that example before any member of Congress did. Having so thoroughly contorted the Commerce Clause with its specious reasoning that it would swallow the Constitution and fundamentally change the relationship between the citizen and the federal government, should not the federal government provide some explanation respecting the contours of this new authority that it demands? Perhaps this court will make such an inquiry of the government, and that is exactly what those two judges did. They wanted to know, what are the limits to this power, let alone the authority? And the government's lawyer could not tell them. And as I just said, the reason is there are no limits. What they demand here, ladies and gentlemen, is that we dismiss 400 years of American experience. 400 years since before the American Revolution. Now, in the wake of the Revolutionary War, as we explained to the court, the nation was on the brink of financial disaster. The central government was largely without substantive authority and in disarray. With the Articles of Confederation ineffective in practice, leaders from the several states gathered in Philadelphia at the Federal Convention of 1787 to address the Article's many defects. Among their most pressing concerns was dealing with the Confederacy's inability to effectively construct a stable national economy. James Madison, from Madison's notes at the Federal Constitutional Convention, noted that the predatory and retaliatory taxation visited on some states by their neighbors resulted in, now I am quoting his notes, New Jersey placed between Philadelphia and New York being likened to a cask tapped at both ends, North Carolina between Virginia and South Carolina to be a patient bleeding at both arms, quote unquote. Prior to the adoption of the new Constitution, the regulation of commerce never ceased to be a source of dissatisfaction and accord. So commerce at the time the Constitution and its Commerce Clause were drafted and ratified consisted of selling, buying, bartering, as well as transporting for these purposes. In short, the framers understood there needed to be a unified national authority for regulating the flow of goods. And the Supreme Court's historic 1824 Commerce Clause decision, Gibbons versus Ogden, demonstrated that the framers intended for the Constitution to mean what it said. Now, individual mandate. The government's Commerce Clause analysis is dependent on this court accepting that an individual's decision not to purchase health care, that is, an individual's inactivity, substantially affects interstate commerce. That's a first. Also, the federal government's conception of health care is not one where millions of citizens each exercise their individual judgment to make separate and rational decisions on how to manage their own particular health and welfare. Rather, the federal government sees Americans as groups and classes to be regulated. But this is not Plato's Republic, Thomas More's Utopia, Thomas Hobbes's Leviathan, or Karl Marx's Workers' Paradise. It is a constitutional republic where individuals are free to decide for themselves whether or not to participate in commerce. And by any objective standard, the individual who forgoes purchasing health insurance has made a decision not to engage in commerce. And in America, that's a perfectly free and legitimate decision. This case is the most important civil rights case in modern times. And it is among the most important civil rights cases of all times. And it doesn't just affect one group of Americans or another. It affects every single citizen in this country, even the damn fools who vote to be enslaved, even the damn fools who argue to be enslaved. We fight for their liberty too. We fight for their liberty too. Because our government seeks to enslave all of us. I'm not talking about gulags. Where in the Constitution does the Congress have plenary power over us to pass whatever it wants, whenever it wants? Is there a single founder? Is there a single man at that Constitutional Convention that made such an argument? Quite the contrary. They made the opposite argument. They tried to create a central government that wouldn't consolidate all this power. So they not only enumerated the powers of the federal government, they divided them among three branches. And more than that, in order to get the Constitution ratified, they agreed in advance that once it would become ratified, they would send a so-called Bill of Rights to the states. At that time, 12 amendments, 10 of which were passed. Once the first Congress met, and the states quickly ratified them. And there it is, the 10th Amendment, which most courts ignore. Yet it was crucial to our founding, crucial to the establishment of this government. I don't care if you're Republican, Democrat, liberal, conservative. I don't care what your race, ethnicity, religion is. I don't care what your sexual preference is or what your sex is, or if you don't even know what your sex is. The fact of the matter is, this is a liberty case. This is a liberty case. We cannot have these temporary politicians, which is how I refer to them time and again, making permanent and devastating decisions about this society. No group of politicians should have this kind of power. Period. None. So this is the leading civil rights case of the day and one of the biggest civil rights cases in American history. Governor Christie of New Jersey, you should be ashamed of yourself, sitting on the sidelines, letting everybody else do the heavy lifting, and all you had to do is sign a brief, costing you nothing. I just read you a direct quote from James Madison's notes at the Constitutional Convention, and one of the reasons we have a Commerce Clause is because Philadelphia and New York City were putting the pinch on the state of New Jersey. Where's the governor?